Hi everyone, welcome to week 7 of your Law and Ethics for Pharmacy Technicians course. This week we are covering chapter 6. And for those of you who are in my 116 course, this should be a fairly easy chapter for you because this chapter is all about HIPAA. And if you are in my 116 course, you know that entire course is around HIPAA. So this is just a kind of a brief overview of HIPAA. And what it's all about and how it fits into our job. So basically, when we think of HIPAA is all about the ability to be able to move or port information back and forth. So that's where it comes from, that it's Portability Act. So portability means movement. So transferring and transmitting information back and forth to allow continuity of healthcare. Now, the idea that most people think of when they think of HIPAA is privacy, right? Privacy is definitely part of HIPAA, but it is just one small part. So we're going to look a little bit about the use and the disclosure of our protected health information, how that fits into our role as a pharmacy technician, how we can make sure that we are protecting patients' information and all of those types of things in this particular chapter. One question, that comes up a lot is, what can I or can I not say to someone else? And that's probably one of the most important things, is understanding how you can comply and what you need to do to make sure you are complying with the goals of HIPAA. So let's take a brief look at the pieces of HIPAA, and then we'll talk a little further about your role. So the first part of HIPAA is all about COBRA. So making sure that when you leave a job that you have continued health coverage. So that's the first part of it. It was health insurance reform, making sure that when someone left a job, they could continue that health coverage for a certain amount of time. And so then Title I of HIPAA was a modification of COBRA. So giving things like exclusions for pre-existing conditions, ability to enroll in new plans and things like that. Then we added on Title II, which restricts electronic transfer of healthcare data, gave patients more rights to their personal health information. Better security was put into place, and the idea of reducing paperwork and kind of simplifying the process and streamlining things was a big part of this. So the whole idea of electronic data interchange was the next step or the next piece of this. So there's 5 basic provisions of the Title II part of HIPAA. It's that whole idea of benefits coordination. That's where the electronic health information is part of. So, when it's submitted through electronic means, then we don't have to go back and forth when you have more than one health insurance, that type of thing. There's penalties assigned. So if you don't do what you're supposed to do, there are penalties to those things. There is, of course, privacy issues, which again, that's just one small piece of HIPAA. And then the timetable, which at that, is kind of past now for all of us, but they had a certain amount of time to ramp up to get in everything in place to be able to comply with HIPAA. And then, how does state law fit into all of that? They address that in Title II as well. So the folks that are required to comply with HIPAA are what we call covered entities. And covered entities are basically 3 groups: clearinghouses, health insurance plans, and healthcare providers. So as a pharmacy and pharmacy technician, we would be considered healthcare providers. We're going to be communicating, obviously, with health insurance plans. So we're both considered covered entities. So anytime we have a state law that's more stringent or more tough, that's the one we have to comply with. So a lot of times that has to do with record keeping and things along those lines. So keep that in mind. As with any other law, whichever one's the more strict is the one we have to follow. So we have all kinds of controls over storage and management of the personal health information. All of this came about because of that privacy rule of 2003. And so this is where, that information that's in our system belongs to the patients. They have a right to control who can look at it. You may have heard of previous cases where notes were passed along within, I believe it was a Walgreens system, where they had put things in there like, something personal about the patient, about their behavior when they picked up a prescription or something like that. And that information was viewable by the patient because it is still part of their personal health information. So all of those types of things are important to keep in mind when we're talking about PHI. And then, of course, we have the medical records. The entire medical record is the patient's information again. So when we think about PHI, it's really important that we understand all of the different pieces that are part of that. So these are just a few of the pieces that are included. And it's really anything that can be used to identify a patient. So even things like email addresses, their vehicle information, photographs, all of those kinds of things are identifiers. So we have to keep that in mind when we are thinking about protected health information and how we keep our patients safe. Patients do have a right to view it, and they can request that at any time. So again, we have to make sure that we are protecting that information. So as you go through and you are reading through the chapter this week, if you have any problems or questions, please make sure that you are reaching out to me, and have a great week.